Mr. Baldry. My Lord, could I just pick up 2 points that arose out of the questions this morning? One was, I think Lord Hodge asked whether the general system for dealing with deductions of tax paid at source allowed the payer to deduct inward payments that he'd received from which tax had been deducted against the obligation to deduct tax on payments made, and the answer to that was yes. Generally, it all sort of fed through so that you didn't have to identify a specific payment with a specific onward payment. You could collectively deduct tax that had been deducted on your payments. The second point was in response to a point Lord Briggs asked on, well, what would happen if the contract said pay 100? And that was actually sort of dealt with specifically in paragraph 7 of Schedule 23A, page 864.
Oh, I think I saw it.
7B, it says, in any case where the aggregate of an amount paid by way of a manufactured overseas dividend and the tax required to be accounted for in connection with the making of that payment, i.e. the RWT charge, would exceed the gross amount.
Well, is that right? I was looking at entitlement to payment rather than actual payment. Because one assumes if you've got an entitlement to an annual payment of 100, but tax is deducted at source, you actually get paid 70.
Yes, but so I thought you were looking at the position if the actual payment was...
No, I'm not looking at the payment, I'm looking at the entitlement to payment. Yeah. And recognising that paragraph 4.2, I think it is, sorry, in 4.1 is very precise in terms of talking about the payment actually made in discharge of the requirement rather than the gross entitlement.
Yes, and that simply was the...
I mean, it seemed to me to be covered by 4.1 rather than the later paragraph that you've just referred to.
Yeah, that reflected the...
yeah.
I mean, our basic point on the OSLAs is that however they were drafted can't affect the question that you've actually got on the compatibility. The next was on before we go to the Court of Appeal's specific decision, we'll run through our points on that. There's the offsetting regime generally. We've touched on it. We've set out in our written case the effect of the provisions. There's also a helpful summary of them in the revenue sort of guidance notes on this regime, which the courts below sort of found of assistance in getting an overview, because the regulations themselves are fairly densely written. That's at page 3376. Paragraph 13 is just dealing with an overview of the amounts that you can offset under Regulation 9. And this is if you are an approved UK intermediary, which in the present case all the borrowers were. Paragraph 13.2 just listed the amounts that the ORCU could use which were eligible for set-off under the general rule of Regulation 9, and that included tax in respect of real dividends as well as mods. And then paragraph 13.4 said that no offsetting is allowed where real or manufactured overseas dividends have been matched with manufactured overseas dividends paid under the provisions of Regulation 10, except where such dividends are received net of eligible tax and have been matched with payments made under deduction of tax, net against net. So that's a sort of typical situation where the borrower receives a dividend from which tax has been deducted, or a mod from which tax has been deducted, and in the same period pays a mod to the lender. In that case, there is what's called a sub-pool, but they're matched together, and the setting off is automatic on a claim by the ORCI. And when that applies, tax on the real manufactured overseas dividends received can be set off only against the tax on the matched overseas dividends paid. So if you had matched dividends, you would look to see what input tax had been charged on the receipt, and that would be set off against the tax due on the payment, and that was the only place where that deduction could be made. So the ORCI couldn't, if there were a case where the relevant withholding tax was greater, then the general offsetting provisions wouldn't apply. But in the cases that we've been looking at and all the sample dividends, the rate of overseas withholding tax that was applied was always the relevant withholding tax equal to the relevant withholding tax applied here. So 13.5 is important to note that the consequences of offsetting, this was part of the scheme, was that double tax relief can only be claimed to the extent that tax within the paragraph 13.2, i.e. that's the offsettable amounts, exceeds the tax due. And one of the objects of the scheme was, once that tax had been granted to the lender, then if the offsetting took place in the hands of the borrower, who might have actually received the dividend, the borrower wasn't entitled to also receive double tax relief credit in respect of the same dividend. So you might say that the scheme had the primary purpose of ensuring that the benefit of the credit for the overseas tax was granted to the lender. You know, that was achieved through the medium of the synthetic dividend in the way that we've seen. In the ordinary case of a chain of lending, where simply a borrower or another borrower in the UK receives the dividend, then matching took place, and the credit for the overseas tax that had been withheld by the company just flowed through to the lender. That sort of matching process is described in more detail in paragraph 15. And so where you had that matching, the credit just flowed through to the lender. If a dividend of 85 was paid to the ORCI or to another UK intermediary, then the 85 would be the only amount of money in the pot. That would flow through to the lender, and the matching would take place. And in that case, the ORCI wasn't entitled to claim any relief for the overseas withholding tax, so it was only granted once. That was the matching rules, and then there's the further rules that you fall back onto the general offsetting provisions if the dividends weren't matched. In that case, particularly if the ORCI sold the share, there's no way that you could trace through to the tax credit through a lending chain. In that situation, the actual dividend might have been paid wherever, and then the ORCI wouldn't have a direct credit which it could offset under the matching rules against its liability, but in that case it could then utilise the general offsetting rules against its general credits from wherever. And so one way of describing that process is if the credits didn't automatically flow through to the lender, you couldn't trace the dividend through the chain going up to the lender, then they had to be sort of funded in UK tax terms by the tax charge on the ORCI. So the ORCI was liable to pay the relevant withholding tax, but subject to its ability to offset and practical terms, because the ORCIs were financial traders with lots of surplus DTR credits, they didn't actually pay any tax over. So with that sort of background, if you look at the impairment analysis of the Court of Appeal, where the Court of Appeal said that the effect of the regime overall was that the pension fund was not able to obtain the returns that it might otherwise have obtained from stock lending. And we just have 5 points to take with that analysis. The first is that one of the difficulties of the Court of Appeal's decision is that it doesn't identify sort of precisely what aspect of the mods regime meant that the trustee was not able to get a better return. And that matters because the trustee is not arguing for disapplication of the entire mods regime. It wants to keep the grossing up provision in 4.2 in isolation and to treat that as a non-deeming provision. But the Court of Appeal appears to have been contemplating that there was a situation where the ORCI was able to lend the share to a person overseas who would be entitled to receive a dividend of a higher amount than the dividend that would be received in the UK, and that the ORCI and the trustee and the recipient would sort of carve up the difference between them, so that the pension fund would be able to get a share in that. And we think that the scenario which the court is contemplating is similar to that set out in scenario 2 of the trustees' written case at page 141. So, according to this example, the trustee lends Italian shares to the ORCI, and then the ORCI lends shares onto a French company, where the relevant rate of withholding tax between Italy and France is 5%, and the French company therefore receives a dividend of 95. Net of 5, and on this analysis, the French company pays a mod of 95 to the ORCI. Now, the trustee doesn't draw express conclusions from that example, but seems to suggest that the ORCI would be out of pocket because the ORCI is liable to the reverse charge, and that's the charge under paragraph 4.3, which says that if a person receives a mod from outside the UK, such as an ORCI receives a dividend, or a mod from outside the UK under this regime, they have to account for relevant withholding tax as if they were the person paying that, but then they can set off that charge against their liability to relevant withholding tax. So we say that actually analysis is not right as a matter of detail. In that case of our sort of hypothetical example, which we think the Court of Appeal is thinking of, the ORCI would in fact not have to apply the reverse charge, and that's because of a particular provision, regulation 7.2e, which is at page 872. Refers to various cases where the charge under paragraph 4.3, or the reverse charge, is disapplied, and one of those is 7.2e at the bottom of the page, where an ORCI, in receipt of a manufactured overseas dividend, who shows that the overseas dividend manufacturer concerned was entitled to payment of the overseas dividend, of which the manufactured overseas dividend is representative, either as holder of the securities concerned, or directly or indirectly for such a person. So if there's an arrangement between the ORCI and a French shareholder by which the share is transferred to France and the dividend paid, then in all likelihood the ORCI would be aware of that and would run 7.2e. The effect of that is that...
Oh, I'm sorry, you're assuming that there's layer upon layer of mods.
I'm assuming that there is a mod paid by the ORCI to the pension scheme, and yes. I'm looking at what does the ORCI entitled to do with its liability.
Yes, but under 7.2e, that's dealing with a situation where there is an ORCI in receipt of a mod.
Yes, so the mod is that would include a manufactured overseas dividend paid by someone in Italy, France, and as long as it's contractually, it's a manufactured overseas dividend. The ORCI has onward lent the share to somebody in France, and the person in France now has received a dividend of a bigger amount than the lender would receive.
Yeah. But that's not scenario one that the Court of Appeal's envisaging. The ORCI uses the shares to satisfy its obligation to deliver 1,000 shares under a short sale.
Well, that was another example. I think one of the examples given by the Court of Appeal was the situation where the shares were transferred to a person who enjoyed a lower withholding tax rate.
You were referring to scenario 2, weren't you?
Yes. Oh, I beg your pardon. Yes. Right. I misnoted that. I'm sorry, I had difficulty hearing.
So we're now in the situation looking at the onward loan of the share to France and the mod being paid by the French company to the ORCI. I'm saying that on that analysis, 7.2e would apply, and where 7.2e apply, the effect of 7.3a, capital A, on page 873, is that effectively the ORCI is treated as having paid the reverse charge, but only of an amount limited to, the wording is the excess of the gross amount of the overseas dividend over the amount of the overseas dividend received by the overseas dividend manufacturer, i.e. the French company. And there is a typo in 3A, just the sort of third line up, where it says in the square brackets where an amount equal to the excess to the gross amount of the overseas dividend. That should read of. But if effectively what this is doing is saying that yes, the ORCI who receives the dividend gets a credit for the tax which has been deducted in real life, but the credit which the ORCI gets is limited to the amount of the actual tax which has been withheld by Italy on the dividends to France. So the ORCI is then treated as having paid the reverse charge of only 5 in our example, because that's the only withholding tax that actually applied, and it can deduct that 5 from its withholding tax obligation. So on the Court of Appeal's analysis of that type of situation, it's true that if there is a chain of lending and the dividend rate which is applied to the actual dividend, so let's say the 5% withheld in Italy on the dividend to France, is less than the relevant withholding tax rate applied to the UK, the 15 on our example, then the amount which the ORCI has to offset against its relevant withholding tax liability of 15 would be limited to the amount of 5, namely the actual withholding tax applied. So in that case, the ORCI has an obligation to account for the full 15.
Was there any evidence as to how this works in real life?
No.
Shares are it is. I wouldn't have imagined it was practical to trace chains of ownership of shares. If the ORCI sells them or lends them on, and that person in turn sells or lends on, but very quickly it'll become impossible to trace an individual share and work out what withholding tax may have been actually applied to the dividend payable in respect of that share. And under the contract itself, when we looked at the contract earlier, it requires the borrower to pay the income on the share less the withholding tax, subject to issues arising about UK taxes. But presumably that contract can't be envisaged as requiring minute tracing of share ownership.
No, and the evidence that, before the, I mean, bear in mind this whole argument about offsetting an impairment was nothing to do with the trustees' pleaded case. So there's no evidence about any of this, of how it worked in practice. We're simply trying to work out what underpins the Court of Appeal's reasoning. In practice, the evidence was that the trustee agent handed the shares over, and the trustee had no visibility of what happened. JP Morgan just prepared these schedules which showed on the sample dividends what the relevant withholding tax was, and you simply got those from looking at the double tax treaty and saying, well, on this Italian share, if it had been paid to here, it would have been 15. So that's the only thing that was relevant to anybody in practice.
But if that's right, then the receipt that the lender receives, the payment the lender receives, is not affected by file a tax regime, except for the fact that because he's not exempt from tax, he would never have been able to recover the withholding tax, unlike an entity that was a taxable person.
And
if the tax regime didn't exist and he simply lent Italian shares, he would get back 85. Because of the tax regime, he still gets back 85.
Yeah.
And his problem, if you like, is that whether the tax regime exists or not, he can't reclaim the 15 because of the fact that he's exempt from paying taxes.
Yeah.
The Court of Appeal's example raised or discussed?
I think what was raised at the hearing and in the upper tribunal was the fact of this differential. My friend's point is that mods are treated differently from manufactured dividends because it's based on this sort of hypothetical construct, and it's based on this tax being deducted from this dividend, which nobody knows what actually happened to it. And we say, well, that's all irrelevant because the basic construct of the gross amount of the manufactured dividend is the gross amount of the dividend that would have come to the UK. So we say this is all a sideshow, but because of the I think there were a number of hypothetical examples that the Court of Appeal asked us to produce notes of, and we did. So they're somewhere in the bundle. So this may well have been one of them. So there were lots of permutations of what might have happened if the ORCI had on-lent the shares, but for all the permutations, as the sample dividends showed, the trustee always got the 85. So. But that was simply to explain what we didn't go through with the Court of Appeal, because it hadn't been part of the pleaded case, as to why this might have made a difference. The Court of Appeal inferred, well, because the actual shareholder might have received a bigger dividend than the pension fund. The pension fund would have been in a position somehow to get a benefit from that, and because it didn't, the pension fund has got to be given a remedy which gives them not simply the amount which they might have lost out of, but always, in every single case, the full amount of the 15. So part of our first sort of criticism of the Court of Appeal's probably on analysing restriction is that it didn't sort of sufficiently identify what was the restriction, what were they complaining about, and that caused problems later on when it came to the remedy. The second problem is that the theory is entirely speculative, as the Trustees says in its written case at paragraph 122.5. That's just a complete matter of speculation whether the commercial returns were impaired, and that does go to the issue about whether if there is any difference in treatment, whether the restrictive effects are too remote or not, and indeed whether they arise as part of a situation that's within the scope of Article 63, because it is restricting the trustees' movement of capital to to Italy in the first place. We've cited a couple of cases in our written case. They were both on sort of free movements of workers or free movement of goods, but as Advocate General Cocotte had said in her opinion in Mannanen, para 28, for your reference, page 1187, that it's the same concept of restriction applies to capital movements. And in the BASF case, Authorities Volume 1, Tab 6, 962, that concerned rules about having to have certain patents translated into every single language, and if you didn't have your patent translated, then in Germany you weren't entitled to register it. And the court said that, well, that sort of restriction depends on actual unforeseeable decisions taken by each of the operators concerned in the light of economic conditions existing in the various markets. And even supposing that in some circumstances the division of the market may have restrictive effects on the free movement of goods, those repercussions are too uncertain and too indirect. So if you do have possible restrictions which are uncertain and indirect, then that is not sufficient to constitute a breach of Article 63. And that's the sort of speculation we say that founds the impairment analysis. It sort of speculated that the possibility of the trustee transferring its investment to a third party, and the third party doing something in its business which really we can't assume. And the third problem is that even adopting that speculative approach, it's completely unclear why the French company, why the ORCI, would pay the trustee a manufactured dividend of an amount greater than the dividend, the manufactured dividend it got, together with the fee that it got. The trustee said in evidence that the borrower was free to do what it wanted with the shares when they are lent. That was the witness statement of Mr. McCormack, page 765 to 766, and his evidence, paragraph 54, was that one of the borrower's motivations may have been to undertake arbitrage or short sell, but those were matters for the borrower. And if on the evidence the borrower was free to do what it wanted, there's no reason to infer that it would wish to share its profits with the trustee. Our fourth objection to the Court of Appeal's analysis, one we touched on earlier, is that it doesn't address whether any difference in treatment applied to mods compared with manufactured dividends amounted to discriminatory treatment, which essentially entails different rules being applied to comparable situations. And this is a sort of distinct element in the analysis, which recognises that a restriction under Article 63 shouldn't arise if the difference in treatment arises out of different rules which are being applied to situations which are not comparable. That's essentially a rule that's been developed in the case law. The same concept is expressed in Article 65 of the treaty, but that has been sort of considered to sort of embody the earlier case law. And whether or not situations are objectively comparable, it isn't a matter of sort of factual similarity. It depends on the aim of the provisions in question, and what's the purpose of the scheme in which the situation arises. There are many propositions for that. A murder at Authorities, Volume 4, tab 45, at page 2186 is one of those. Haribo, paragraph 84, in case you would have considered looking at the FII decision, that's page 1129. And one case I would like to take you to, which is the Orange European Small Cap Fund. That's Authorities, Volume 6, tab 71. So electronic page begins at 3010, 3010. And this case concerned Dutch entities known as fiscal investment enterprises. The basic nature of those were described at paragraphs 3 and 4 on page 3044. And as it says in paragraph 4, under Dutch law, these fiscal investment enterprises were subject to 0% corporation tax, but were obliged to distribute almost all their profits to their shareholders. And the Orange Small Cap Fund was such an entity. It invested in a range of overseas shares. Because it was subject to 0% tax, it wasn't entitled to make claims for double tax relief under the terms of various treaties. And it one of the common clauses in one of the double tax agreements based on the OECD model is that if you're going to get tax credits, you've got to be subject to tax. So it followed from that from the point of view of a Dutch investor, it was less attractive to invest in overseas shares through the fund compared with investing directly. If the investor benefited from double tax relief directly, it would get the double tax relief. And to rectify that position, the Dutch authorities paid the enterprises what was called a concession, set out at the bottom of page 3046. Essentially, they gave them a payment equal to that which a taxable person would have been entitled to under the relevant double tax convention if it invested directly in the underlying shares. But the fund's entitlement to make to get a payment of this concession was dependent on its ability to make a hypothetical claim for double tax relief. So it could get the concession and the payment in relation to dividends on shares in respect of which the direct investor would be entitled to the credit. But it couldn't make a claim for the concession in relation to dividends from countries with which the Netherlands didn't have a treaty, or where the treaty did not have a right of set-off of the withholding tax withheld in the country. And I think there were two, Germany and Portugal. The Germany-Holland double tax treaty didn't provide for any right of set-off for withholding tax withheld in Germany, and there wasn't a treaty with Portugal. So under the concession paid to the investment enterprise, there was no payments in respect of withholding tax referable to Germany and Portugal. And the fund complained that this was a breach of EU law, and it made a claim for a payment of the concession, which included withholding tax on German and Portuguese dividends. That's paragraph 16 of the decision, page 3049. And it was saying that the Dutch rules discriminated against the German and the Portuguese dividends, as opposed to the dividends from the other member states, because it didn't grant any concession. You didn't get a payment in respect of the German and Portuguese dividends, and that was contrary to Article 43. And their complaint is recorded at paragraph 43 on page 3059. And the court held at paragraph 56 on 3062 that difference in treatment did give rise to a restriction. So the court says at 56, by excluding from the concession dividends originating in certain member states, legislation as that at issue in the main proceedings makes investments in those member states less appealing than investment in the member states in which the taxation at source of those dividends gives rise to the concession. So yes, there was a difference in treatment of the German and the Portuguese dividends. But the court then turned to what's now Article 65 and the issue of objective comparability at paragraphs 58 and 59. And the court held that the situations of the German and Portuguese dividends were not objectively comparable to the other dividends. And they looked at the purpose of the rules at paragraph 62 to 63. The Dutch system was aimed at ensuring that taxable investors in the investment enterprise weren't disadvantaged through investing through the investment enterprise as opposed to investing outright. They were not potentially disadvantaged in relation to investments in Portuguese or German shares because they wouldn't have been entitled to the tax credit in any event. It's about 62, 63. So the court was saying, well, look, it's true that the Netherlands didn't grant payments in respect of dividends from those two countries, but that's a difference in treatment. But looking at the scheme more broadly, the investors, who this was intended overall to benefit, wouldn't have got a greater return from the Portuguese and German companies, because that would have been subject to withholding tax, which they couldn't claim because there wasn't a relevant treaty. So looking at objective comparability involves looking at the overall purpose and structure of your legislation.
I thought that the usual formula, so far as I'm aware, is the purpose or the effect of the legislation. And here they're looking at the effect. When you were making your submissions just now, you seemed to be suggesting it was all just about purpose, but it's not confined to that, is it? One looks at the effect.
No, it's not confined. Right. But purpose is certainly an element of it. As everyone's looking at the effect in the context of a particular scheme which has a particular purpose. It was relevant that the rules here were aimed at ensuring that the taxable investors weren't disadvantaged. And had the claim succeeded here, the fund would really have got an additional benefit in the sense that the fund knew that the shareholders wouldn't be able to claim the benefit of the DTR credit on the dividends if they'd invested in them themselves. And what the fund was doing is saying, well, look, the fact that the Dutch regime didn't actually involve DTR credits itself, but they created this special regime intended to deal with sort of synthetic DTR claims. Looking at that regime itself, you could see there was a difference in treatment, but the courts have looked at it more broadly. So that was orange small cap.
It's my fault, but I've become slightly adrift from the analysis in this case. So was the court saying there was a restriction for the purposes of what is now Article 63, but it was justified under some other provision?
No, there was a restriction, but because the restriction arose in circumstances where the two situations that were being contrasted were not comparable, it was not a restriction that was precluded by Article 63. It's in the analysis, objective comparability is dealt with as a different, conceptually different from justification. There are the justifications which arise on the case law where you have a restriction and the member state is seeking to say, well, this restriction can be justified on overriding grounds of the public interest, so fiscal cohesion, matters like that. Objective comparability comes at a slightly earlier stage. It accepts that there is a difference in treatment which was liable to dissuade, but because it arose out of a situation which wasn't objectively comparable, then it's not precluded by Article 63.
I think we see that on page 3063 in paragraph 57 of the judgment. Having concluded that there was a restriction which it was prohibited in principle, they then go on to quote Article 58(1)(a) of the treaty, which says that the Article 56, without prejudice to the right of member states to apply provisions which distinguish between taxpayers who are not in the same situation. So it's a treaty provision that you're referring to here.
Yes.
So is the order of analysis that you look to see if there is a restriction, but it might be saved if you bring yourself within what was 58(1)(a)?
Yes, if the situation...
And then subsequent to that, one can ask the question of justification.
Yes.
There's three questions, is that right?
Yes. And sometimes the court refers it expressly to the article in the treaty. There was another case that we've referred to called Buanik, where I don't think the court expressly looks at the article, but it considers the same issue in language of discrimination. It first looked at whether there was a difference in treatment, which was in principle liable to give rise to a restriction. And then it said, well, we've still got to answer this before we can get to see whether that restriction is precluded by Article 63. One has to ask, is it discriminatory? But in asking whether it's discriminatory, the court said, well, that involves finding a rule that applies, the same rule that's being applied to situations which are not objectively comparable.
Right. It's probably my fault, but I thought the Court of Appeal, I'm now looking at paragraph 29, page 279, on the Article 63 point, just asked, is there a restriction on movement of capital? Is it justified? So they seem to have left out your second comparability.
Yes, they did. I think they mentioned, the Court of Appeal mentioned that we'd put that in our skeleton, but we weren't relying on it. And I think I'm relying on it more in the context of the Court of Appeal's impairment analysis. I mean, if the trustee's primary case were right, and we've simply taxed their income we've taxed their overseas income completely, and we've just not taxed their domestic income, then its objective comparability is a little bit more complicated, but
And sorry, where did the Court of Appeal said that you didn't press this point?
yes. Oops. It would be paragraph 43.
Thank you.
I do remember we looked at the decision of Buanik in that case, and certainly it's the same analytical process. Look at is the restriction, then ask, is that discriminatory, which involves considering whether the difference in treatment arises out of things that are not.
And again, am I missing something? Yeah, I'm looking at the statement of facts and issues now, pages 62 to 63. You don't seem to have identified an issue on Article 65 there.
Yes, it's no, it's not as a separate issue, and in the later cases, it's not Buanik. It's not Article 65 is really not considered to be the relevant. It's part and parcel of the question about whether there is a restriction that's precluded, and that involves looking at whether it's discriminatory or not.
The end of 62B is.
Sorry.
Yes, I mean, it's objective comparability. Yes. It traces its origins in Article 63 back to the separate article, but the case law says, well, that just expresses the principles that have been developed by the court before Article free movement of goods, free movement of capital was introduced. So it doesn't add anything additional, and it can't. Member states can't rely on that to get away with applying discriminatory provisions. And the trustees' case says that this is discriminatory, but we say it's not. And the objective comparability is very much part and parcel of the discriminatory question.
And I see that now, and it is my fault, but does objective comparability come in under Article 65?
Yes, it's the same concept.
It would be helpful if there's a reference to Article 65 there. That you say, B is Article 65 point. So
yes.
Thank you. That's sufficient.
And our fifth criticism of the Court of Appeal is where, and final, is where they say that the 67, that the revenues case faced the same difficulty at every stage of the analysis, namely that no actual withholding tax was necessarily imposed on the foreign dividends. And the upper tribunal had similarly thought there was a key point, and the courts were again here accepting one of the trustees' criticisms of the revenues case. The trustee says that our whole case is vitiated by a central flaw, in that it's reliant on the doctrine of parallel exercise of taxing rights, but we do not rely on the parallel exercise of sovereign taxing rights as providing the answer to the restriction issue. The parallel exercise is simply important because it explains the background as to why the tax treatments of the real dividends were compliant with EU law. It simply finds the background basis for the fact, which is common ground, that the trustee only got 85 on its real dividend, and that was not a breach of EU law. So that feeds into liability to dissuade, and one then looks at well, what is in this legislation that is liable to dissuade, and it's if the trustee would have received 100 on an Italian dividend but only 85 on a manufactured dividend, matters would stand differently.
I'm sorry, I must have lost the thread here. What is your criticism of paragraph 67 of the Court of Appeal?
I think they're saying there that the revenue's got this the difficulty at every stage. So I think we took from that they thought that even when we were looking at restriction, they say that the mod regime is a construct which they based in some respects on the withholding tax regime, is separate from that latter regime. So I think what they're saying is that we are simply saying that the principle of parallel exercise of taxing rights is an answer. The court is interpreting us, because that's how they were asked to interpret us, as saying it doesn't matter that we've deducted tax from your dividend, trustee, because that just puts you in the same position that you would have been had the dividend been paid direct, and that was okay. But what we're saying is that the explanation between the difference between the 85 and the 100 is simply based on the dividend that the trustee would have received, and we're not imposing an extra tier of tax on that income. So the trustee simply got what it would have got. So we are not relying on the principle of parallel exercise of taxing jurisdictions to defend the withholding tax deduction under para 4.2, saying that it doesn't impose tax.
Mr. Baldry, another hour has passed.
Yes.
And you've got 1 hour left, and you still have to deal with justification, whatever you want to say about Article 65, yeah, and Article 64 rather, and the question I flagged up, yes, at the very beginning of remedies.
I'm done on restriction. So I think if I could turn to the Article 64 at the standstill.
And we're hearing this obviously subject to whatever Mr. Gamme may have to say about your entitlement to raise the issue at this.
Exactly, and we not raised this before. Before the FTT, we had a discussion about whether this was a direct investment or not, and we concluded it was. If I can take you to Article 64. I think we've cited in our written case at, on page 109. Which says that the Article 63 is without prejudice to restrictions which exist on 31st December 1993.
You missed out was to the application to third countries of any restrictions.
Yes. Involving direct investment and the provision of financial services. And the point that we seek permission to raise is, again, it's a point that emerges certainly more clearly to us out of the Court of Appeal's analysis, in that it was the Court of Appeal's analysis that appears to say that the trustee should be entitled to benefit from the sort of activities of the ORCI, which we would say involve provision of financial services. This court has recently considered points about new points in the FII case. That's not in the bundle, but I think it's been provided to you separately. But there are only two paragraphs I would draw your attention to in FII 2020 UKSC 47 and paragraphs 89 and 90, where the court cited Singh and Das and Notting Hill Finance, and it summarised there was a spectrum of cases where a new point may have required new evidence, and on the other hand, points of pure law. And so we obviously say that the point here is a point of law. If so, it would have the effect of carving out claims which have been made in respect of third countries. So the argument would be that the trustee has made movements of capital in the sense that they've invested in shares in third countries. I think one of the sample dividends was a Japanese company. But if there is a restriction in this case, the issue is, does that restriction involve the provision of financial services? And we say, if the Court of Appeal is correct in its impairment analysis, and it forms the basis of the finding of restriction, the key problem with the MODS regime was one which sort of prevents the trustee and the ORCI together engaging in activities such as arbitrage with a third party, and that involves the provision of financial services. There's one authority we've referred to on financial services called Wagner-Raith at 2707, where the court considered what was a financial services for the purpose of Article 63. And it's a fairly sort of straightforward issue of German legislation, which it's page 2707. German legislation dealt with distributions arising from investment funds situated in the Cayman Islands, and imposed a particular tax treatment on the recipient where the funds hadn't complied with certain statutory obligations. And at paragraph 46, the court held that investment in an investment fund necessarily involved the provision of financial service, since all the acquisition of the units in the investment fund and the receipt of the dividends deriving from them involved the existence of a financial service provided by that type of investment fund. So they contrasted that with simply a direct acquisition of company shares on the market by an investor. And so in the present case, if it said that the problem with our regime is that it prevented the trustee from sharing in the arbitrage type opportunities which the ORCI would carry out, then that would be a matter which involves the ORCI carrying out financial services and providing a service to the ORCI, and the trustee could be seen as providing a service to the ORCI by lending its shares to them.
Well, it's described as a loan, but in reality it's selling its shares, isn't it?
Yes, yeah, it's a transfer of shares outright. But if the problem with the legislation is that we should have been entitled to transfer our shares on terms that we would get a further return on what you make of them in your financial trade, then that's gone way beyond the sort of passive investment of a direct investment. It's the trustee would be doing something over and above. And of course, we say that this didn't happen. The trustee was simply acting as an investor, and the trustee did no more than simply transfer its shares. But the Court of Appeal's analysis does require one to think, well, the trustee would have done all these other things.
Yeah.
But I mean, buying and selling a share, one wouldn't ordinarily, I think, describe that as a provision of a financial service. It's selling an asset.
Yeah. But
why isn't the analogy closer with the idea of investing directly into the underlying companies in the Wagner Wraith case?
Well, I suppose it's because it's all to do with that. Although it is transferring the share as a matter of law, it's transferring the share and keeping the economic benefit of the share through the manufactured dividend, and on top of that, seeking to exploit differentials in other tax treaties, which the ORCI might be able to manage to get an extra return on your manufactured overseas dividend, and at the end of the day, that you get your share back. So there's a lot more sort of activity going on in that sort of hypothetical situation, which the Court of Appeal is contemplating, than the ordinary investor buying and selling the share.
Yes, thank you.
And if I ask another question, I mean, Article 64 is concerned with the application to third countries of etc. etc. When a borrower, a UK borrower, enters into a UK lender rather, enters into a contract with an ORCI, and it's subject to this tax regime, in what way is that the application of restrictions to a third country?
Well, I mean, the whole point of the trustee's case is that this activity going on between the ORCI and somebody in Italy is restricting its rights to invest in shares in Japan. The relevant movement of capital which the trustee says is being restricted is the acquisition of shares in Japan, and we say, well, we've gone a long way from that anyway. But if we're still in Article 63, if there is a restriction because the trustee has been denied the chance of sharing in the ORCI's trading profits made from this Japanese share, then it's now become involved in the provision of involves a financial service. I mean, the restriction's got to be about discouraging the trustee from buying the Japanese share. So it is the restriction being complained about applies to third countries, and it involves, on the Court of Appeal's analysis, provisions of financial services.
I see. So if the taxation of the payments made under the contract between the lender and the ORCI have the effect of constituting a restriction for the purposes of Article 63, then you say, yes, for the purposes of Article 63, then you say Article 64 must, in principle, be available.
Yeah.
I see.
I think the trustee said, well, although this legislation came in before December 93. There were there have been changes made to it since, and they pointed to some changes in 2007, which effectively said that if there was any sort of differential treatment between the relevant withholding tax rate as between the ORCI itself and the pension fund. So if and they pointed to Germany, where under the German treaty, the relevant withholding tax rate was lower if the share was lent to an ORCI than if the pension fund had kept it. And the effect of the 2007 changes on that particular example meant that the trustee, the relevant withholding tax would be determined by reference to the tax charge on the withholding tax charge that would have applied on the dividend to the ORCI. So they say, well, in that particular example, the trustee was less well off, but it varied. I mean, it depended on what the rate was. There'd be other cases where the trustee would be better off by these changes, but we would say that under the case law, such as Conley that we've referred to, and FII in Authorities 1, page 953. The essential question on this point is whether any changes take the same approach as the previous legislation, and it's only where the legislation is amended to be based on a different approach, or to sort of establish new procedures. And we say that all the 2007 changes we're doing was dealing with a couple of anomalies to reinforce the previously existing purpose of the legislation, to ensure that the MOB was treated as if it was a dividend in the hands of the lender. And so that purpose is furthered by ensuring that where the double tax treaty takes into account the status of the shareholder, so does the MOD. Well, we've set out our submissions on that and our written case at 136, so I don't need to go further into that point. So that was all I was proposing to say on the standstill provision. So turning to justification, so here, I mean, again, as in every step, the precise analysis on justification will depend on the type of the restriction that's being justified, and we would say if the restriction arises out of the impairment thesis, the detrimental consequences of the MOD regime to the trustee is not essentially the deprivation of the 15 which it would otherwise have received. The impairment analysis really is saying that the trustees lost the chance to engage in and profit from the activities of the ORCI. And the case laws recognise that a measure which is liable to hinder a freedom may be permissible if it pursues a legitimate objective. This is true justification. And so the twin phrase is it pursuing a legitimate objective compatible with the treaty, and is it justified by overriding reasons in the public interest? And if one's looking at the objectives, and is that an objective compatible with the treaty? Well, yes, the basic objective of the mods regime was to free up overseas stock lending and to make it sort of tax neutral. So that policy aim was to remove impediments and is a legitimate objective. So do we come within any of the two recognised forms of justification? And the two that we've relied on is balanced allocation of taxing rights and fiscal cohesion. And on balanced allocation, we make sort of 3 points. The first is the court sort of correctly analysed the case law such as SGI in paragraph 52 of its judgment at page 288 by saying that balanced allocation is now treated as separate from tax avoidance. This is part of the development of this justification was that it was formerly twinned with tax avoidance, but it's now seen as as a more sort of self-standing justification. And more recent cases such as fidelity funds, which is in the authorities bundle at page 2632, simply looks at balanced allocation. The second point is, well, what does balanced allocation refer to? And we say here that the case law shows that this justification can be accepted, in particular where the national system is designed to prevent conduct capable of jeopardising the right of a member state to exercise its tax jurisdiction in relation to activities carried out in its territory. That's SGI, paragraph 60 on page 3121. And the Court of Appeal's objection was, well, this is really nothing to deal with, to do with that kind of prevention. It looked at the sort of cases like SGI and FinCap, which are essentially looking at measures such as the arm's length rule, by which states are saying that, well, here are the profits which we say are sort of properly attributable to this state, and we agree with our counterparty that, say, interest deductions shall be prohibited for tax purposes if they're above the arm's rate, and the effect of that is to ensure that profits aren't moved from one state to the other state. And certainly that is an example of balanced allocation, but there's no reason to think that the categories are closed, and we would say that treaty provisions dealing with withholding taxes are another instance of two states agreeing between themselves how the taxing rights over the dividend income, which represents the investment activities of the fund, should be allocated. So there is no sort of in principle objection to it. And the third point is that the Court of Appeal's criticism that HMRC's argument, they said, had the mods regime had nothing to do with striking a balance between the taxing powers of the UK and the taxing powers of the member state in which the company paying the dividend was resident, because the Court of Appeal's analysis was, well, this is a contractual payment between a UK ORCI and a UK pension fund. The actual dividend may have been paid elsewhere, so this scheme has nothing to do with balanced allocation. But we say that that's looking at the scheme, the starting point of the scheme in the UK, was that to ensure that the taxable lender was put in the same position vis-à-vis the tax credits that have applied to the dividend that has been lent, and certainly in the matched case, all that's happening is that the dividend is being paid sort of indirectly through the ORCI to the pension fund, or being paid, in the case of a taxable person, it's being paid indirectly to that taxable person. The dividend flows up the chain. So in that sense, it's just a look through down to ensure that the double tax is being relieved in the appropriate place.
But as you explained earlier, the shares may have changed hands many times.
Yes.
The contractual payment isn't necessarily the remittance of the original dividend through successive hands back to the lender.
Yeah. No, certainly the mod isn't the same thing as a dividend, but it represents the economic benefit of the dividend. And in the ordinary case where the dividend flows through, there's an alignment between the rate of the withholding tax actually imposed on the dividend and the rate of the relevant withholding tax on the final mod, which represents that dividend. So I can't say that the mods regime had nothing to do with real withholding tax in that situation.
But the actual dividend will have been paid to whoever the current owner of the share is, who will then be, if I mean, there may or may not, in fact, be withholding tax withheld, but if there is, then the recipient of the dividend will then have whatever rights he has under his domestic legal system to reclaim that tax, depending on whether there's a double taxation treaty in force or some sort of default provision. It will depend on the laws of whatever country he's based in.
Yeah, that's if the ORCI's sold the share, that is the case. But if there's a the ORCI may not have sold the share at the time the dividend was paid, or he may have lent it to another UK ORCI, in which case it would be exactly the same, just the mod would have travelled down the chain. But all that's happening there is that the double tax relief, which has been agreed as between the UK and the overseas state, is being relieved at the right place. Yes, it's true. If there's a sale, then it changes. But the reason for that is all links with the original dividend are lost. But even in that case, indirectly the UK is giving effect to the agreement, because the UK is saying yes, the lender will still get the tax credit because we're treating this mod as economically equivalent to the dividend. And as far as the lender's concerned, that's what it is. So that was a balanced allocation. And next was fiscal cohesion, because of a narrow point. The Court of Appeal summarised the case law on fiscal cohesion at 62, 64 of the judgment, and we don't disagree with that. And halfway down paragraph 64, when summarising the findings of the Court of Justice in FII 2, the Court notes that the doctrine of fiscal cohesion requires there to be a direct link between, on the one hand, a tax advantage, on the other, a particular tax levy. This game will be familiar to you as the issue arose in the context of the second reference to the Court of Justice in the FII case. That second reference was case C3511. And one of the main issues in FII was whether the UK's imputation system gave rise to a restriction on the free movement or freedom of establishment or the free movement of capital. And the court held that the UK's imputation system for overseas dividends was not equivalent to its exemption system for domestic dividends. And specifically, they held that granting a tax credit for overseas tax actually paid led to an additional tax, effectively, if the effective level of tax that was applied to the overseas subsidiary was less than the nominal rate in that state. So that was the restriction. And the court went on to consider whether an imputation system which gave a form of credit but was less than exemption could nevertheless be justified. And part of that analysis required the court to consider whether the relationship between the tax credit under the UK system for relieving economic double taxation and the underlying tax charge constituted a sufficiently direct link. So the FII case is at page 3171. And on this issue, the court dealt with justification beginning at paragraph 56 at 3184. And here they were looking at the UK's actual system, which was to grant a tax credit for overseas tax if it had actually been suffered by the subsidiary company, whereas in the domestic system they gave a complete exemption from tax on the dividends. So could that be justified? And first they looked at the question about whether there was a sufficient direct link. At 58, in accordance with the settled law, the existence of a direct link must be established between the tax advantage concerned and the offsetting of that advantage by a particular tax levy, and the direct nature of that link falling to be examined in the light of the objective pursued by the rules in question. And they held within the UK's system there was such a direct link between, on the one hand, 59, the tax advantage granted, namely the tax credit in the case of foreign source dividends, and the tax exemption for nationally sourced dividends, and on the other, the tax to which the distributed profits had been subject. So underlying it, there had been a tax charge in the hands of the subsidiary, and the purpose of the tax credit was to give the advantage that would set off against that tax. So in the present case, if we're now considering the situation where the mod withholding tax sort of operated as a restriction and was a disadvantage, but the tax credit for the lender was equal to the amount of the relevant withholding tax, which represented the tax chargeable on the dividend. So the tax advantage granted to the lender, namely the tax credit, had an equivalent link with the tax charge, the relevant withholding tax. So if one's looking at the cohesion of the UK's system, the purpose was for one to be set off against the other, and it would disturb that system to sort of say that was an insufficiently insufficient link. The two were supposed to go together. And as the court then goes on to deal with proportionality in this case, because they said that the UK's domestic system in FII didn't comply with the principle of proportionality, because on the one hand you had exemption, and on the other hand you were confined to looking at the actual tax, which had given rise to the problem which they'd found in restriction. So the approach they took was to say, well, you can you can effectively eliminate the restriction we've identified by, you don't have to go so far as providing an exemption. You can provide a credit at the nominal rate. But that sort of nuance doesn't arise here, we would say, because the credit is always equal to the balance by the RWT charge. And no one is suggesting that the credit should be measured by anything else than the tax charge on the hypothetical dividend. So we would say that the system, even if it produces a technical restriction, is a coherent and rational system with the sufficient link between the two charges, so that is justified. That was what I was proposing to say on remedy. I've taken it quickly, but we've set out case law quite fully in our written case. So I was proposing to move on to remedy now. And the starting point with remedy is to remind ourselves there's only one available remedy for the trustee in these proceedings, namely a repayment of income tax, which has either been paid by the trustee or paid on its behalf, and which the statute entitles the trustee to reclaim.
That's a revenue submission. The only possible remedy is restitution of the tax.
I'm just looking in this particular appeal.
Yes.
That'll
be a San Giorgio claim, is it?
The underlying basis of trying to get to what the conforming construction is may be San Giorgio. We'll have to take into account all the principles of European law, but just what it was, the sort of the formal nature of this appeal. It's an appeal under the Taxes Management Act. I think the trustee has made sort of protective High Court claims, which may give rise to San Giorgio restitution claims or damages claims or whatever. But this appeal is a claim under the Taxes Management Act for tax which has been overcharged by the taxing statute, and the only basis on which the trustee can get the tax back under that statutory basis is if the income tax statutes can be interpreted in such a way that they say that the trustee has an entitlement to repayment of income tax.
I don't follow for one moment. If it's a breach of Article 63 and there's inconsistent legislation, you disapply the legislation. No question of interpreting it need arise.
Oh, well, if you disapply the legislation, then the question arises: what effect does that have? So, if you simply disapply the mods rules, then that doesn't allow the trustee to claim what it's claiming.
Well, if there's no statutory warrant for the charge, then there's no constitutional basis for the revenue to hold on to the money.
But in order to do that, one's got to identify what is the unlawful tax that's being charged.
Yes, exactly.
Yes, yeah. But the effect of whether you're conforming construction or you're disapplying some part of the taxing statute.
Yeah. We did try to explain in the last FII judgment that conforming interpretation is a bit of a red herring here, because mar leasing is to do with the implementation of directives and whether or not there's been a correct implementation. But if there's simply a breach of a treaty provision, then you're into factor-tame territory.
Yeah, well, I think that the approach that you adopted in FII is worth having a look at. I think the only point I'm making is that in the difference between the FII's and High Court claims and the present claim is that if you're pursuing your remedies as a matter of common law, your restitution remedies, then if you disapply that part of the statute that is unlawful, and you can identify some tax that's been charged on your income, that can support your High Court claim. The different procedure that you need to go through in the present case is that the effect of the disapplication has got to be that the trustee is either treated as having paid or has actually paid tax under the taxing statutes to which it has a right to repayment.
But is this a, I mean, I don't know, is there a restitutionary claim being made on the basis, I don't know, of payment under a mistake or on a Woolwich basis?
Not in these proceedings, but yes, there is a protective. This is a statutory appeal, so the trustee is saying you must read this statute as if we had received an annual payment of 100, from which 15 has been deducted. And if you do that, what we would have been able to do on our self-assessment returns is to have said, well, we've received income of 100, we were entitled to income of 100, from which 15 has been deducted. On the self-assessment returns, you put in income 100, tax deducted at source 15, and the revenue will write you a cheque for 15.
Yes. So I'm sorry, I hadn't realised this. So in these proceedings, there is actually a statutory claim to repayment of overpaid tax under the TMA.
Yes. Yeah.
Right.
And there is, I believe, there are High Court claims which were protective High Court claims which would be made for restitution and/or damages and anything else. But the main purpose of this, well, the two purposes of this these proceedings to work out whether there's a breach and what the breach is, because that will, in any event, determine what remedies are available elsewhere, but also to determine whether the claimant's statutory claim is good, and it's only good if the effect of the disapplication is to leave the trustee in a position that you read the statute and you say, well, yes, that means that tax has been deducted from its income, which is really the effect of the disapplication that the Court of Appeal and the Upper Tribunal adopted.
That is, in fact, one of the reasons why I asked you this morning about what the mechanism is if you have someone who is liable to income tax for realising the value of the tax vouchers. Because, I mean... Yeah, well, that's a different...
No, that's a different sort of procedure, because there, I mean, the company who is gets the voucher would be using that voucher just as evidence to get the benefit of the tax credit, which they would use to set off against their taxable income. But it's not a payer, it's not, as it's a credit for overseas withholding tax, as soon as you run out of taxable income to set against, which you've set your credit against, you don't get a payment from the revenue. So you use tax credits to discharge your tax liabilities. So you might get a voucher if you're a taxable person, and you can use that voucher to show to the revenue that you've suffered overseas tax on your dividend income, and then you can get the benefit of the credit to reduce your UK tax liability. So
So it's not as simple as the trustee saying, I want to vindicate tax vouchers in exactly the same way as someone who is subject to income tax.
No, because the limitation for the way that the tax credit was given for overseas withholding tax was that the taxable person has to gross up the dividend by the amount of the tax credit. So the taxable person receiving a dividend from Italy gets a net payment of 85 from Italy and an entitlement under the double tax treaty for a credit in the UK in respect of the 15 tax deducted in Italy. And in practical terms, the taxable person treats his income as being income of 100. That's section 795 of the ICTA. He grosses up the income to 100. He then applies the UK tax charge to that 100. His income for tax purposes is 100. He is taxable at, say, 30% on that 100, so he has a liability to UK tax of 30, but he can set, he produces his voucher and says, look, I've suffered 15 of tax in Italy. The treaty says that the UK will give me credit for that tax, and so the revenue says, right, you can have, we will deduct 15 from your tax bill.
So why can't the trustee ask for some form of conforming interpretation which in effect deems them to have received taxable income at 15 in your example, that they have an exact matching liability to income tax of 15, which they can use the credit against, so it's in substance to get the benefit of the tax credit of 15.
Well, they would need to show, and that's effectively what the Court of Appeal and the Upper Tribunal, but they would need to show that that cures that is the thing that cures the inconsistency between European law and domestic law. They'll have to first identify, as you did in the FII case, what causes the restriction, and then apply a conforming construction or disapplication of the particular measure that causes the problem. And then if the effect of that particular disapplication is that the trustee is treated as if it has received, ought to be treated as received, entitled to income of 100, from which 15 has been deducted, then the trustee's claim wins. But we say...
do we have in our bundle the statutory provision under which repayment is sought?
We have, well, as ever, there is no exact statutory provision.
Well, you told us it was being sought under a provision of the Taxes Management Act of 1970.
Yes, I think that the claim that's been made has been made under Section 42 of the Taxes Management Act 1970, which is just a general provision which says that if you're making a claim, you have to make it within 6 years.
A claim for what? For the repayment of tax?
Any 42 is
might help if we had Section
claim,
42.
No, any claim that is prescribed by the Taxes Acts. Now, there is no claim that is specifically prescribed for this claim. The nearest it comes to it is Section 33 of the Taxes Management Act, which entitles a person to make a claim for payment of tax overpaid under a self-assessment.
And sorry, do we have any of these provisions in the bundle?
We've got Section 42. The underlying...
Where will we find Section 42?
No, Section 42 is not in there.
I don't think it is in the bundle. I was once we went on to remedies, I was looking for the provisions of the Taxes Management Act, because if your argument is that certain remedies aren't available under this process, then we need to see the provisions and understand them.
Yes, I mean, I'll bring the provisions. We can send the provisions overnight, but you will not find a statutory provision entitling a trustee to reclaimment.
And that doesn't matter.
No,
I mean, it's a directly effective right under the EU treaty.
And I think that's the approach that's been taken below. And if we've gone so far as to say that we can read the legislation, the substantive provisions, in a way that's sort of compatible with EU law, then there would need to be some moulding of the provisions of the Taxes Management Act, because what the trustee is saying that...
Well, the court can just make an order for you to pay the money. We don't need a statutory basis for it other than, I suppose, the basis of EU retained law.
Given that this is a claim for taxes which have been overpaid under the statute, ordinarily one would require the statute to be moulded.
Well, if we can find a statutory provision that fits, so much the better. But ultimately, if we can't, if there's an accrued right under directly applicable, in fact, if it's a treaty, directly applicable and directly effective EU law, the court has to give effect to that.
Yeah, we've not sort of countenanced that so far, because we've always assumed that the moulding would take place within the confines.
Well, if that's possible, then so much the better. But then you have to explain to us how to do that, and we'll need to have the provisions in front of us.
Yeah. this was sort of touched on briefly in the first tier tribunal, what the nature of the trustees' claim was, and there were two statutory provisions which seemed to both parties to be the ones most closely fitting the current situation. One was Section 33, which provides for a right for overpayment of taxes declared under assessment, and the other one was Section 42, which simply says, provides a mechanism for making a claim required under the statute. And the analysis is that there's another provision of the Taxes Management Act, Section 59, which essentially says what you have to do when you're filling out your tax return. And in your filling your tax return, you put in your taxable income and you put in tax deducted at source. Yeah. And you, the effect of putting in tax deducted at source, if you haven't got any taxable income, is that the tax is repayable. So you'd have to mould that. So, but we can describe that.
I mean, it's true it works both ways around. So Mr. Gammy has to show us some relevant statutory provision which he says can be moulded, but you're trying to say it can't be, or that other provisions have to be moulded in different ways. Either way round, we need to look at all the provisions in play, don't we?
Yes, exactly. But I think that in terms of the limitations on this court, the main limitation in this case comes from damages claims. This isn't framed as a claim for damages if the impairment analysis produced by the Court of Appeal isn't met by a disapplication, and if the loss that's really being suffered is in the form of a damages claim, then the answer of this court will inform how that damages claim might be pursued. But in terms of, that's not the claim that the trustees are making. The claim the trustees are making is saying we want to be treated in the same way as the recipient of an annual payment of 100 from which tax has been deducted. If we're treated in that way, we have a statutory claim for the repayment of the tax.
But it's also not the way that you claim it should be dealt with, as I understand it, because you point to different legislative provisions and say, well, mould these.
Exactly, yes, exactly.
So as I understand it, we're not being asked to address a fallback damages claim in these proceedings because there are the High Court proceedings which have been launched, as you say, on a protective basis.
Yes.
But what we're confronted with are, at the moment, arguments from you as to which provisions should be moulded and how, and arguments from Mr. Gammy as to which provisions, different provisions, should be moulded and how.
Yes.
Okay. And we haven't looked at those at all yet.
No. No.
We don't have them in court.
Well, I mean, I think the main burden of the dispute here is how do we mould the provisions that we have got, Schedule 4, because that is going to determine whether there is an amount of income from which tax has been deducted. The starting point is that there is no income from which income tax has been deducted because of the rules as they exist. We would need to do something with that in order to get the trustees to the position they want to be. And if we get through that process, the actual mechanics of moulding the statutory provisions within the Taxes Management Act are less of a hurdle, but we will provide those provisions tomorrow.
Yeah, but we can't be, as it were, in a Schedule 23A straitjacket in trying to remedy a breach of the EU treaty, which ex hypothesi has arisen out of Schedule 23A.
And one way of looking at it in these sorts of cases is that if there is incompatibility with the legislative regime as prima facie construed, and one's looking to see if a conforming interpretation can be found, one's looking at the whole regime, because in a sense, that pressure might be released, by one bit of the regime without needing to produce more dramatic surgery on another bit of the regime. And indeed, as I understand, that's rather the nature of your case. But that does rather bear out what my lord was just saying, that we're not confined to just looking at paragraph 4. We have to have a sense of how things fit together within the whole regime and where that EU law pressure might be released in a suitable way.
Yeah. Yes, yes. The court has the full powers of interpreting the full acts
well, we are not confined to the Taxes Acts. That's the whole point of a breach of EU treaties. You're not confined by domestic law in trying to sort it, except insofar as domestic law gives effect to the EU regime. That's why one speaks about San Giorgio claims rather than using some domestic terminology.
Yes,
they're not statutory claims.
Well, the true analogue of a San Giorgio claim would be a sort of restitution claim, which is the sort that your lordships have been concerned with in the FII. And
yes, that's why those are authorities on common law remedies.
Yes.
Because there wasn't a statutory remedy, so one's having to adapt the common law so as to meet the needs, meet the exigencies of providing an effective EU remedy.
And likewise, in the present case, you'd be doing a similar process, but starting from the basis that you're working from a statute, and you've got a statutory claim, and therefore whatever...
Well, if we can, we can. I mean, in the Littlewoods case, for example, which is all about overpaid VAT, we were able to use Section 80 of the VAT Act as a vehicle for ordering repayment, because it was perfectly apt to the situation. And if you can show us an apt statutory provision, fine.
Yes, but the two were Section 42 and Section 33, which we'll bring along tomorrow.
Well, I'm afraid you run out of time. If you want to address us on this tomorrow, you'll have to eat into your reply time. Oh, no, I do beg your pardon. I beg your pardon. I'm misreading this.
Till 12:30 tomorrow.
Yes, you've still got till 12:30 tomorrow. Right, well, we better adjourn then for the day and see if we can make more rapid progress tomorrow.